So in response to the Supreme Court's recent decision in the New York State Rifle and Pistol Association v. Bruen case, a new lawsuit has been filed which aims to remove a state's ban on the purchase and possession of suppressors. So let's talk about this. But real quick before we jump into this video, if you think the NFA and the GCA need to be done away with, go ahead and hit that like button and subscribe. Also want to thank everybody who has subscribed to the channel over the last week or so. You guys have been absolutely amazing. I mentioned that one of my goals before the end of the year was to try to reach 400,000 subscribers. You guys absolutely crushed that. We are already almost approaching 410,000 subscribers. So I just wanted to say thank you to everybody who subscribed to the channel. And also just mention if you're not currently subscribed, consider subscribing, and that really does help this channel to grow and to reach more people. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level while serving as a staff attorney with the Firearms Policy Coalition legal team. My goal with these videos is not to provide any legal advice, but instead to give you greater insight into the inner workings of Second Amendment litigation and also help you understand what's currently going on in the battle for our right to keep and bear arms. As I mentioned in the intro, in this video we'll be discussing a new case which was just filed to remove a state ban on the purchase and possession of suppressors. The case we're going to be talking about in this video is called Morse v. Raoul. This is a lawsuit filed in the Southern District of Illinois, and it aims to remove the state of Illinois' ban on the purchase and possession of suppressors. This case is actually very important because although 42 states actually allow for the ownership and purchase and possession of suppressors, there are 8 states within the US which actually do not permit that. Those 8 states include California, Delaware, the District of Columbia, Hawaii, Illinois, Massachusetts, New York, New Jersey, and Rhode Island. This lawsuit seeks to challenge those types of suppressor bans. This lawsuit uses the Supreme Court's recent ruling in the New York State Rifle and Pistol Association v. Bruen case to attack this state ban on the purchase and ownership of suppressors. In Bruen, the Supreme Court issued a 6-3 opinion authored by Justice Thomas, which struck down the state of New York's May issue CCW licensing scheme, essentially finding that it was inconsistent with this nation's history and tradition. One of the primary findings of Bruen and why that decision was so important is that it showed that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. In that opinion, Justice Thomas stated that despite the popularity of the two-step approach, it is one step too many. Step 1 of the predominant framework is broadly consistent with Heller, which demands a test rooted in the Second Amendment's text as informed by history. He went on to state that but Heller and McDonald do not support applying means and scrutiny in the Second Amendment context. In keeping with Heller, we hold that when the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. To justify its regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulations. Only if the firearms regulation is consistent with the nation's historical tradition may a court conclude that the individual conduct falls outside the Second Amendment's unqualified command, and that unqualified command that he's mentioning there in that quote is the text of the Second Amendment, which states, "shall not be infringed." So now under this Bruen framework, the state of Illinois and other states that have a ban on the purchase and possession of suppressors, they must justify those bans using relevant history and tradition of the Second Amendment dating back to 1791. This lawsuit aims to finally make a state actually explain how a ban on suppressors, ban on the purchase and possession of them, is in fact consistent with the text of the Second Amendment. Now let's take a look at some of the arguments that's made in this case. First, the plaintiffs state that the Second Amendment guarantees individuals a fundamental right to keep and carry arms for self-defense and defense of others in the event of a violent confrontation. They go on to clarify that the Second Amendment extends prima facie to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. That statement right there is actually really important because it's well established right now in the legal world that the type of arms here in question, these modern arms, are in fact protected under the Second Amendment. It's not just muskets that are protected like you hear some on the left actually argue. In the legal world, that type of argument has absolutely zero strength because the Supreme Court has clearly stated multiple times that modern arms are in fact protected. They then go on to state that the only way that the state can actually regulate these types of arms is if they are in fact found to be dangerous and unusual. However, a suppressor is not dangerous and unusual. and the mere ownership of a suppressor cannot constitute the ownership of a dangerous and unusual item. And therefore, they argue that under Heller and now Bruen, a state like Illinois cannot completely ban the keeping and bearing of suppressors, which is a common arm owned and used by law-abiding people for lawful purposes like self-defense. This first section of the complaint, where the plaintiff is going through and showing that suppressors are in fact arms protected by the text of the Second Amendment, is them qualifying and meeting the requirements that was outlined in Bruen. First, they have to show that this is an arm protected by the text of the Second Amendment, and therefore, once they prove that, then the burden kind of shifts to the government here, to the state of Illinois, where they must justify their complete ban on the purchase and possession of these arms, and they must justify their ban using text and history dating back to 1791. So here the plaintiffs are just simply using the Bruen framework, which was outlined by the Supreme Court, and they're just walking through this test, outlining it perfectly for the court and saying that yes, these are protected arms, and now the burden is on the government to prove that they can in fact ban these types of items. Illinois under state law bans a device or attachment of any kind designed, used, or intended to be used to silence a report of any firearm. Because of this, Illinois has a complete ban on the purchase, possession, the use of these types of items for hunting, self-defense usage, and other types of usage of any suppressor within the state of Illinois. Illinois also in fact actively enforces this ban. For example, in this complaint here, the plaintiffs include a case where in December of 2016, a person was charged by indictment with 5 counts of criminal possession of a suppressor. So the state of Illinois has a ban and they actively enforce it. So Illinois is completely banning a type of arm which at a federal level is in fact legal to purchase and possess as long as you pay that ATF extortion tax under the NFA. And the argument in this lawsuit is that there is no historical basis to support a state's complete ban even prior to Bruen, because the Heller case would clearly point to the fact that a complete ban on any type of arm like this that's in common use for lawful purposes is in fact unconstitutional. However, prior to Bruen, states like the state of Illinois and other circuit courts have been avoiding the proper type of analysis and have been refusing to hear these cases properly because they used a different type of analysis, which was the two-step approach. The two-step approach and the use of intermediate scrutiny also always led to these types of bans being upheld by the courts. However, under the recent Supreme Court ruling in Bruen, the Supreme Court struck down the use of the two-step approach, so finally states like Illinois now need to justify their bans using the proper type of analysis, which is text as informed by relevant history and tradition, and they can no longer simply just get away with these types of bans by claiming some sort of public interest. And through this lawsuit, the plaintiffs are seeking a preliminary injunction and also a permanent injunction, which would enjoin the state of Illinois, their officers, agents, servants, employees, and all other persons from enforcing the state's ban on the purchase and possession of suppressors. So I was waiting for a case like this to pop up after the Bruen decision. Selfishly, since I live in California, I was anticipating that maybe it would happen here first. California also, like I mentioned, has an outright ban on the purchase and possession of suppressors and also other NFA items as well. This is the first case that I've seen pop up challenging a state ban on suppressors, and this is the first one in a post-Bruen world, but I do not expect that this will be the last one. I would suspect that we will likely see many more cases like this also pop up in those 8 other states challenging the state ban on the purchase and possession of suppressors. Also, thank you to the plaintiffs in this case and the attorneys as well. I'm probably going to butcher your names, but it's Stephen Stamboli and Alan Beck. And again, those are the attorneys of record in this case who filed this case. This is a step in the right direction, and it will likely result in many more cases like this also pop up in other states. So again, good case. I like that this case was filed. I will definitely be keeping my eyes on this case, and if we get any more information, I will let you all know. If you have any questions, go ahead and comment down below, and I'll try to answer to the best of my ability. Also, if you like this video and like support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation is built by armed scholars, and this nation will be maintained by armed scholars.